Kidogo tu. Okay. Kapo.
Ukiwa ready. Hapana. Recording sasa ndo nimebosa.
Morning, everyone.
Good morning, all. Welcome to today's court before Honorable Justice Bahar Mwangaza. My name is Herman for the assistant. The matter coming up for judgment is Petition E for 29 of 2024. Honorable Kawira Mwangaza by the Speaker of the Senate of Kenya and others.
Thank you. Who's in the matter?
Good morning, Your Lordship.
Good morning.
The matter, my name is Elias Mutuma. I appear alongside my learned senior Mr. Elisha Mboya, who is in the Great Camp. I also appear alongside Robert Mutembei.
Yes.
Frida Kimathi.
And Frida?
Frida Kimathi.
Frida Kimathi.
That is all for the petition.
Thank you.
Good morning, my lord.
Good morning.
Kanji,
Yes.
for the respondent.
Thank you.
Good morning, my lord.
Good morning.
My name is Boniface Morero.
Yes.
I appear for the fifth interested party. My colleagues, I also want to brief for Mr. Kiremi for the third interested party. He's on his way to the court.
Yes.
Benson Kenya appears for the fourth interested party, is present. And Mr. Eric Murioki appears for the fifth interested party, for the sixth interested party.
Benson Kenya for the?
For the fourth interested party, that is Speaker.
Yes.
And Eric Muriuki for the 6th interested party.
Good morning, my lord.
Good morning.
That matter, my name is Lawi. I appear alongside Ms. Mwangaza, who's present in court.
Yes.
For the first interested party. Council without.
Thank you.
Most praising judge.
Yes, good
Mrs.
morning.
Omondi.
Yes.
I appear alongside Ms. Kawira, who is present in court, holding brief for Ms. Malas, to record USA Kenyans, the second interested party.
Thank you.
Good morning, my lord.
Good morning.
Designing Jamway for the 7th interested party.
Thank you. So the judgment in this matter is ready. We have also prepared a media summary, which I will release at the conclusion of reading the judgment. We have 2 hard copies that I will also release to the parties, one side to the petitioner and one to the respondent. So I'll begin reading. It's 50 pages, bear with me, it'll be quite long. The petitioner herein filed a petition dated 21st August 2024 and thereafter, with the leave of the court, an amended petition dated 23rd December 2024 seeking the following orders. A declaration that the refusal, failure and neglect of the respondent to make a ruling on the question of whether the Senate could debate and make a resolution on a motion involving matters actively pending before a court of law, including an order halting the impeachment process of the petitioner, was arbitrary, high-handed, unlawful, and a violation of the constitutional principles of constitutionalism and the rule of law. B, a declaration that the respondent's conduct and management of the proceedings culminating into the resolution to remove the petitioner from office by way of impeachment was in violation of the petitioner's right to fair hearing as guaranteed under Article 50, Clause 1 of the Constitution of Kenya. C, a declaration that the actions of the respondent to allow voting on the motion for removal of the petitioner from office on 21st August 2024, a day not gazetted as a sitting of the Senate, contravenes its constitutional mandate, hence the resultant resolution to remove the petitioner by way of impeachment emanating from the proceedings of 21st August 2024 is ultra vires, in law, thus null and void. D, a declaration that failure to conclude the business culminating into the resolution to remove the petitioner from office as Governor of Meru County on 20th August 2024, as gazetted vide Gazette Notice number 10123 dated 15th August 2024, and as indicated in the order paper of 20th August 2024, renders the subsequent proceedings constitutionally invalid. E, a declaration that the respondent's decision to uphold the resolution of the County Assembly of Meru leading to the removal of the petitioner from office by way of impeachment was unconstitutional and a violation of the petitioner's entitlement to the rule of law in light of the principles of sub judice, double jeopardy, and contempt of court. F, a declaration that the respondent's impugned resolution made on 21st August 2024 was founded on grounds that lacked the legally established threshold for removal of a governor by way of impeachment. G, a declaration that Section 33, subsection 8 of the County Government Act is unconstitutional in as far as it allows the reintroduction of the same charges which previously failed to result into the removal of a governor at the expiry of 3 months. Viso amounts to double jeopardy and is a clear contravention of Article 50, Clause 2, Paragraph O of the Constitution, which states that a person shall not be tried for an offense in respect of an act or omission for which the accused person has previously been acquitted or convicted. H, a declaration that the Senate, in its evaluation of the impeachment proceedings before it, fails to properly assess each of the specified grounds and determine if they collectively or individually constitute gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181, Clause 1 of the Constitution. Hence, the same be and is hereby set aside. An order of certiorari to remove into this honorable court and quash the decision and/or resolution of the Senate made on 21st August 2024, resolving to remove the petitioner from office by way of impeachment. An order setting aside Gazette Notice number 10351, volume CXX V1 number 130, dated 20th August 2024, published on 21st August 2024, communicating the decision and/or resolution of the Senate to remove the petitioner from office by way of impeachment. And finally, K, costs of this petition be provided for. Background. Following the general elections held on 8th of August 2022, the petitioner was duly elected and sworn in as the governor of Meru County. The petitioner has faced a series of impeachment motions by the County Assembly of Meru, with a motion dated 31st July 2024 receiving an affirmative vote by the 5th interested party on 8th August 2024, which was forwarded to the Senate on the 9th August 2024, pursuant to Article 181 of the Constitution, as read together with Section 33 of the County Government Act. The respondent convened a special sitting of the Senate on 14th August 2024 to consider the notice of motion on the establishment of a special committee to investigate the proposed removal of the petitioner from office by way of impeachment. The notice of motion was not passed, and instead, the Senate determined that the matter would be canvassed before the Committee of the Whole House, with the Senate sitting in plenary. On 19th and 20th August 2024, the Senate heard the matter, with the County Assembly and the Governor presenting their respective cases. At the conclusion of hearing, the Senate voted on the matter, and it passed a resolution affirming the decision of the County Assembly and removing the petitioner from office by way of impeachment. By way of a Gazette notice dated 20th August 2024 and published on 21st August 2024, the respondent, the Speaker of the Senate, gazetted the decision of the Senate to remove the governor from office by way of impeachment pursuant to Article 181 of the Constitution, Section 33 of the County Government Act, and Standing Order 80 of the Senate Standing Orders. On 21st August 2024, the petitioner, being aggrieved by the decision of the Senate, approached the High Court through a petition dated 21st August 2024 and filed on 21st August 2024, and subsequently the amended petition dated 23rd December 2024, which is the basis for consideration in this judgment, on the grounds that the senatorial process violated various constitutional provisions, including the right to a fair hearing, Article 50, public participation, Article 10, the sub judice principle, among other grounds. The petitioner also sought interlocutory relief via a notice of motion application dated 21st August 2024 and filed on the same 21st August 2024, seeking the grant of ex parte and inter partes interim conservatory orders, which this court granted on 21st August 2024 ex parte and confirmed inter partes pursuant to a ruling dated 18th December 2024, pending the hearing and determination of the substantive petition. The petitioner's primary arguments are that the impeachment did not meet the constitutional threshold, that it was conducted in defiance of a valid court order, that it was based on matters already pending before the High Court in Meru, that the process violated the principle of public participation, and that she was denied a fair hearing. The ruling of this court, dated and delivered on 18th December 2024, granted the interlocutory relief for a period of 120 days only, and on 20th December 2024, this court issued comprehensive directions on the schedule for the hearing and determination of the matter, including the issuance of a judgment date being 14th March 2025, which fell within that 120-day period. The petitioner, having been granted leave to file and serve an amended petition, and interested parties having been joined by the court so as to give all concerned parties an opportunity to be heard, filed and served the same, and responses to the amended petition were also filed and exchanged by the respondent and the interested parties. The matter was canvassed by way of written submissions, with the parties filing written submissions in support of or in opposition of the petitioner's amended petition dated 22nd December 2024 as follows. I'll not, in the interest of time, I'll not go through the various filings. Highlighting of written submissions was held on diverse dates as follows. The petition and those in support of the amended petition on 21st February 2025 and 24th February 2025. The respondent and those opposed to the amended petition on 24th February 2025 and 26th February 2025. Positions of the parties. The petitioner, Honorable Kawira Mwangaza, challenges the impeachment process before the Senate only within the amended petition dated 23rd December 2024. The petitioner has made clear that the ambit of the amended petition before this court is limited to the actions and decisions of the Senate, of the respondent and the Senate, with a substantive challenge to the actions and decisions of the County Assembly being a matter that is being canvassed in another petition filed before the High Court sitting in Meru High Court Constitutional and Human Rights Petition number E013 of 2024, which is still pending before that court and is awaiting full hearing and determination. The petitioner's grievances before this court and in this amended petition are thus limited only to the actions, omissions, and decisions of the Senate in the Senate's consideration and determination of the motion received by the Senate from the County Assembly that culminated in the impugned vote and resolution of the Senate made on 21st August 2024. The petitioner asserts that the impeachment was not only procedurally flawed, but also unconstitutional. She contends that several breaches of her fundamental rights, as enshrined in the Constitution of Kenya, occurred throughout the impeachment process before the Senate. Those breaches include violations of her right to fair hearing, the subversion of court orders, the illegal handling of sub judice matters. The petitioner also argues that the actions by the Senate in considering the motion by the County Assembly were in direct contravention of both national laws and judicial precedents that govern impeachment procedures. At the heart of the amended petition is the claim that her removal was tainted by legal irregularities and thus must be declared null and void. The petitioner asserts that the High Court has jurisdiction to hear this matter based on Articles 165, 3b and d of the Constitution of Kenya. According to these provisions, the High Court has the mandate to determine whether any action by state organ, in this case the Senate, is in violation of the Constitution. The petitioner emphasizes that this case revolves around the interpretation and application of constitutional rights, such as the right to a fair hearing and the right to hold public office, which falls squarely within the High Court's jurisdiction. Additionally, she invokes Article 23, Clause 1, which grants the High Court authority to issue orders for the enforcement of the Bill of Rights. The petitioner also argues that judicial review powers under Article 23, Clause 3, Paragraph F provide the court with the authority to quash any unconstitutional proceedings or decisions that infringe upon her rights, as the Senate was acting as a quasi-judicial body and thus is amenable to the supervisory jurisdiction of the High Court pursuant to Article 165, Clause 6 of the Constitution. The petitioner further holds that the respondent, the Speaker of the Senate, is a proper party capable of being sued in these proceedings. Referencing Martin Nyaga Wambora versus the Speaker of the Senate and 5 others, where the Speaker of the Senate was deemed a proper party capable of being sued, since the Speaker played a direct role in presiding over the impeachment process and was responsible for ensuring procedural compliance, the petitioner underscores that the respondent was capable of mounting and advancing a substantive defense on behalf of the Senate, as evidenced from the respondent's filings in this matter. In addition to the respondent having a direct role in the unconstitutionalities and illegalities with which she is aggrieved. The petitioner emphasizes that the Speaker of the Senate permitted the introduction and continuation of the impeachment process before the Senate, which then proceeded to hear and determine the matter, despite the issuance and pendency of conservatory orders by the High Court sitting at Meru. Those orders, which were granted in response to the petitioner's application, ordered a halt to the impeachment process, and thus the Speaker of the Senate and the Senate were in violation of a court order when the Senate heard and determined the motion laid before the Senate. The petitioner contends that this defiance of court orders is not merely a procedural misstep, but a direct violation of the rule of law and judicial authority. The fact that the respondent, despite being aware of the Meru High Court's ruling dated, and the orders therein, chose to permit the Senate to proceed is, in the mind of a petitioner, a clear and determinative violation of the Constitution, which renders all subsequent actions and decisions of the Senate null and void. To buttress this argument, the petitioner has drawn the attention of this court to the Meru High Court's ruling on contempt of court, which was delivered on 13th February 2025, in which it confirmed that the County Assembly, its Speaker and the mover of the motion were found to have acted in contempt of court for having introduced a fresh impeachment motion, which is the impeachment motion that was heard and determined by the Senate. Turning to the sub judice rule argument, the petitioner argues that several issues that formed the basis of the impeachment charges, such as the employment dispute involving, I'll not name the parties, were already pending in courts of competent jurisdiction. These issues were thus sub judice in the mind of the petitioner, meaning they were under active judicial consideration, and thus their discussion in the Senate was unlawful. The petitioner contends that both Standing Orders 90 of the County Assembly and Standing Order 103 of the Senate clearly prohibit such discussions, as they could potentially prejudice the fair determination of the cases before the courts. Despite this, the petitioner argues that Senate proceeded to discuss and to vote on matters that were legally restricted, thus breaching the sub judice rule. The petitioner argues that the Speaker of the Senate failed to make a ruling on the issue of sub judice when it was raised, which further compounded the violation of procedural fairness. This action, to the petitioner's mind, is a gross violation of the constitutional doctrine of separation of powers, as the Senate was discussing and determining matters pending in courts of law, thus usurping judicial authority from those courts. The petitioner relies on several legal precedents to support her case. She cites the Central Bank of Kenya versus Ratilal Automobiles Limited and Omega Enterprises versus KTDC, which assert that actions taken in defiance of court orders are null and void. These rulings reinforce the petitioner's argument that the impeachment process conducted in violation of court orders cannot stand. The petitioner also invokes the Judicial Service Commission versus Speaker of the National Assembly 2013, which held that contemptuous acts, regardless of whether the contemnor was aware of the court order, are automatically invalid. Based on these precedents, the petitioner calls for the court to declare the impeachment process a nullity, quash the Gazette notice that formalized her removal, and declare the relevant provisions of the County Governments Act unconstitutional. The petitioner also seeks a permanent injunction to prevent any further impeachment proceedings on the same grounds, arguing that such proceedings would be fundamentally flawed and illegal. The petitioner argues that the impeachment process itself violated her right to a fair hearing as guaranteed by Article 50 of the Constitution. She asserts that the proceedings in the Senate were marred by chaos, disorder, and an overall lack of procedural fairness. The petitioner describes how, during the Senate's impeachment debate of 20th August 2024, the proceedings were halted multiple times, and the live media coverage was abruptly stopped. Moreover, the petitioner claims that the time allocated for debate was insufficient, with each senator only given 3 minutes to present their views, which was grossly inadequate given the gravity of the matter. The petitioner's closing remarks were also limited to only 2 minutes, during which she was not even able to give her statement due to the ongoing disruptions. Excuse me. Furthermore, the petitioner highlights that the impeachment motion was rushed, with crucial procedural steps ignored, such as adequate debate and an opportunity for questions and clarifications. These actions created an environment where the petitioner could not adequately defend herself, thus breaching her constitutional right to be heard fairly. The petitioner emphasizes that the conduct of the Senate on that night rendered the impeachment process a mockery of justice and were indicative of a preconceived decision, a violation of her right to fair hearing before a fair and independent quasi-judicial body. The petitioner also argues that the impeachment process was fraught with procedural irregularities, which were acknowledged by some senators after the fact. Several senators, in media statements and parliamentary sessions, admitted that the impeachment was unfair, unprocedural, and invalid. The petitioner argues that these admissions lay bare, by admission, the flawed nature of the process that unfolded before the Senate. The petitioner points out that despite these admissions, no remedial actions were taken by the Senate or the Speaker to address the admitted mistakes. The petitioner cites instances where senators expressed regret over the process, including during the impeachment of the Deputy President on 9th October 2024, where the flaws in the petitioner's impeachment were acknowledged and stated as lessons to be learned for the Deputy Presidential impeachment and also for future proceedings. Despite these acknowledgements, the petitioner argues, having been admitted by members of the Senate, can only lead this court to a finding that indeed the process before the Senate with respect to her impeachment was unconstitutional. The petitioner has also attacked the canvassing of charges that had been previously determined in her favor by the Senate during previous impeachment proceedings against her before the Senate. In addition to arguing that this violates her constitutional protection against double jeopardy on a factual basis, the petitioner also argues that Section 33, subsection 8 of the County Governments Act is unconstitutional because it violates the right against double jeopardy as provided under Article 50, Clause 2, Paragraph O of the Constitution. The petitioner asserts that this provision allows for the removal of a governor through impeachment based on issues that have already been adjudicated by the Senate or matters that had formed the basis for previous impeachment motions by the Senate, and it violates the constitutional protection against both double jeopardy and also fair hearing. In conclusion, the petitioner argues that the impeachment process before the Senate was marred by a series of constitutional violations, procedural defects, and contempt of court. The petitioner asserts that the actions of the Senate and the County Assembly were not only unfair but also illegal, rendering the entire impeachment process null and void. She emphasizes that the conservatory orders, sub judice violations, and denial of fair hearing resulted in a miscarriage of justice. The petitioner further contends that the Senate acted in bad faith by continuing with the impeachment despite clear judicial directives. Given these circumstances, the petitioner urges this court to quash the impeachment process, declare it unconstitutional, and uphold her constitutional rights to due process and a fair hearing. The petitioner's position rested with a plea to this court to uphold the letter and the spirit of the Constitution and to find that the electoral mandate bestowed upon a governor can only be extinguished through a Senate process that is free, fair, procedurally sound, and undertaken with utmost fidelity to the Constitution and the rule of law. Respondent's position. The respondent argues that the court's jurisdiction is limited when reviewing legislative action unless a clear constitutional violation occurs. They reference Isaiah B. Watt Kangwonyi versus IEBC 2018, which reaffirmed the presumption of constitutionality for legislative actions. The respondent asserts that the impeachment process against the governor of Meru was conducted in strict adherence to the law. Article 181 of the Constitution and Section 33 of the County Government Act outline the grounds and procedure for impeachment, and the respondent contends those provisions were strictly adhered to. The Senate, exercising its mandate under Article 96, followed the due process as prescribed, ensuring procedural compliance and constitutional validity. Additionally, the respondent argues that the Senate sufficiently evaluated the grounds presented and found them substantiated, citing specific instances of gross violation of the law, misconduct, and abuse of office. The respondent submits that impeachment does not require proving every charge beyond a reasonable doubt, as it is a constitutional accountability mechanism, not a criminal trial. Referencing the Court of Appeals decision in Kioko versus Clark, Nairobi City County Assembly and 11 others, 2022, where the appellate court affirmed that the governor can be impeached if at least one of the charges is sufficiently substantiated, the respondent argues that the substance of the charges were proved and the court should not interfere with the same. The respondent maintains that there was no valid court order preventing the Senate from proceeding with the impeachment. The respondent argues that the ruling relied upon by the petitioner related to a previous motion and not the motion that ultimately resulted in the governor's removal. The respondent clarifies that the court order issued by the High Court sitting in Meru applied to an earlier impeachment motion dated 17th July 2024, while the impeachment proceedings in question were based on a subsequent motion dated 31st July 2024. As such, there was no valid court order prohibiting the Senate's actions. In buttressing this argument, the respondent asserts that the petitioner failed to raise a proper preliminary objection before the House on that point. This position was supported by Mike Sokombuvu Gideon Kioko versus Clark, Nairobi City County Assembly, and others, 2021, where the court ruled that procedural objections must be raised appropriately before legislative bodies, which the respondent argues the petitioner failed to do. Thus, the respondent argues that neither the Speaker nor the House can be faulted on this limb, as the petitioner herself failed to appropriately move the Senate for it to determine the question. The respondent submits that the impeachment proceedings were conducted in accordance with the standing orders of the Senate. The Speaker provided necessary notifications and scheduled hearings which allowed both the Governor and the County Assembly to participate in the process. The Governor was granted an opportunity to respond to allegations and was represented by legal counsel, negating claims of procedural unfairness. The respondent insists that the Governor was accorded a fair hearing throughout the process. She was given an opportunity to respond to the allegations, was represented by legal counsel, and she had the chance to cross-examine witnesses. The respondent argues that the Governor was given an opportunity to make closing remarks but declined to do so. The argument that she was denied the right to be heard is therefore unfounded, since she was fully represented by legal counsel who made statements on her behalf. The respondent cited Sonko v. County Assembly of Nairobi and 11 others, Supra, where the Supreme Court held that procedural requirements for impeachment are met, including proper notice, evidence presentation, and legal presentation, the decision is sound. The respondent justifies the decision to limit the debate on impeachment motion to 3 minutes per senator by arguing that this limitation was approved by the Senate in accordance with its standing orders, 111 of the Senate standing orders, which allow the House to impose such limits and guides how impeachment trials are conducted. The respondent adds that the motion to limit the debate was duly voted upon and passed by a majority of 31 to 9, making it a legitimate procedural decision and did not violate any constitutional provisions and is in accordance with established rules. the Speaker's decisions regarding procedural matters, including limitation of debate, were legally sound. The respondent references Uzalendo Institute for Leadership and Democracy versus Attorney General and another, 2021, where the court upheld parliamentary autonomy in regulating its internal procedures and argues that this court cannot interfere with the internal regulation of the proceedings of the Senate. The respondent also submits that the voting process in the Senate was conducted in strict compliance with standing orders. Senators voted electronically, with some manually casting their votes in accordance with procedural rules. The outcome of the vote reflected the will of the majority. The respondent further contends that parliamentary proceedings are governed by established rules, and no evidence was adduced by the petitioner to demonstrate any disorder affected the validity of the vote. The respondent justifies the Speaker's decision not to adjourn the impeachment proceedings despite alleged disorder on this basis. They cited Erskine-May's Treatise 2011, which states that the Speaker has discretion to determine whether disorder warrants adjournment, and the respondent argues this is a matter over which the court has no jurisdiction in determining. The respondent opposes the petitioner's claim that Section 33, subsection 8 of the County Governments Act contravenes Article 50, Clause 2, Paragraph O of the Constitution, which prohibits double jeopardy. They state that impeachment is a political process separate from criminal proceedings, and thus Article 52(o) does not apply since it governs criminal trials and not political accountability processes such as impeachment. That provision, to the respondent's mind, is necessary to uphold governmental and leadership accountability, and the respondent cites Hastings versus United States, 1992, where a judge was impeached despite prior acquittal in a criminal trial, and it was held that impeachment is a separate political process from criminal proceedings and does not fall within the ambit of double jeopardy protections. The respondent highlights the laws enacted by Parliament enjoy a presumption of constitutionality. In Isaiah Biwot Kangoni versus IBC and another, Supra, the court held that courts should only declare a law unconstitutional if it clearly contravenes express constitutional provisions, which is not the case with Section 33, subsection 8 of the County Governments Act. The respondent cites Article 117, Clause 1 of the Constitution and Section 12 of the Parliamentary Powers and Privileges Act to argue that legislative proceedings are protected from judicial interference. Referring to the case of Apollo Mboya versus Attorney General and others, 2018, where it was reaffirmed that parliamentary debates and resolutions cannot be challenged in court unless there is clear evidence of unconstitutionality, the respondent argues that no such basis has been laid in the present case. The respondent also argues that the doctrine of separation of powers requires that courts should not interfere in the internal workings of Parliament unless there is a clear violation of the Constitution. Citing the Supreme Court in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another, 2017, which emphasized that judicial restraint is necessary when dealing with matters constitutionally assigned to other arms of government. The respondent challenges the probative value of the petitioner's evidence, including social media posts and newspaper articles, arguing that they constitute hearsay and thus were inadmissible for failing to meet the requirements of the Evidence Act. The respondent, relying on IEBC versus National Super Alliance, NASA Kenya, and 6 others, 2017, submits that such materials constitute hearsay unless verified by their authors, which the respondent asserts was not done in this case. Additionally, Section 106, capital B of the Evidence Act sets strict conditions for the admissibility of electronic evidence, which the petitioner fails to meet as per the respondent. The respondent argues that the impeachment decision was reached after full deliberation and was supported by evidence. The respondent cites the Sonko decision, where it was established that where due process is followed, the court should not overturn the Senate's decision simply because the impeached official disagrees with the outcome. The respondent also argues that the amended petition is incurably defective due to the failure to enjoin the Senate as a party. The respondent contends that the Speaker was not a proper party to sue, as he is an ex-officio member of the House with no vote in any of the impugned matters. The respondent points out that the impugned decision and resolution were taken by the Senate and not by the Speaker, and further that the adverse prayers sought relate to actions and decisions of the Senate as a deliberative body exercising its voting discretion. And it is trite law that adverse orders cannot be sought against a party who has not been sued and is not participating in the proceedings. The respondent further notes that the petitioner had ample opportunity to cure this defect when granted leave to amend the petition, but she did not sue the Senate. Since the Senate as an institution made the decision to remove the governor, it is only that body that could properly respond to the claims raised and not its Speaker. The respondent, in canvassing this limb of its defense, points out that in the Meru High Court matter number E013 of 2024, the County Assembly was sued by the petitioner and not by the petitioner that the legislative chamber must be sued in order for adverse orders to be sought against it. The respondent asserts that the orders sought by the petitioner, including the nullification of the impeachment, are untenable because the process followed the law strictly, and the petitioner is in essence raising minor procedural lapses that do not go to the root of the matter and the substantive finding by the Senate. Adding that the petitioner cannot benefit from claims of procedural violations that she neither contested to or failed to challenge at the appropriate time, the respondent contends that the petitioner is clutching at straws in a feeble attempt at escaping the logical outcome of a just and fair constitutional process that found her liable for gross violations of both the Constitution and statute law. Finally, the respondent contended that the impeachment was not politically motivated or discriminatory, nor was it a preconceived decision. They argue it followed established legal frameworks and cited Bhavana Patel Mandalaya versus Chetan Arun Solanki 2021, where the court emphasized that evidentiary requirements must be met for claims of bias to succeed. The respondent concludes by urging this court to dismiss the amended petition in its entirety, arguing that the impeachment process was lawful, that the petitioner was accorded due process, and that the claims made in the amended petition are without merit. The respondent urges the court not to act in substantive merit review of whether the Senate ought to have affirmed or dismissed the charges against the petitioner, but rather only limit itself to whether the law was followed in the process, which the respondent emphatically affirms was the case. The Senate acted within its constitutional and legal mandate. The petitioner was granted a fair hearing, and the impeachment process met the required legal standards. Therefore, the order sought by the petitioner should not be granted. The first, second, and seventh interested parties' position supporting the amended petition. The seventh interested parties' reply and written submissions were struck out by the court due to improper commissioning of the replying affidavit, which meant there was no underlying foundation for the interested parties' written submissions. However, it fully supported those of the petitioner and the first and second interested parties in support. The first, second, and seventh interested parties fully associated themselves with the petitioner's case and supported the amended petition wholeheartedly. In terms of fresh ground covered, the first interested party, the Council of Governors, argues that the court should uphold the sanctity of impeachment and not affirm a process that was marred by irregularities. The Council of Governors' position was that the present case is indicative of a worrying trend in which impeachment has become watered down and the bar for it has become too low. Additionally, the first interested party faulted the Senate for conducting the voting on a day that was not gazetted as an official sitting date, which renders the entire process unlawful in its eyes. To the Council's mind, the manner in which the impeachment was conducted raises fundamental questions about whether due process was followed, and if not rectified, it sets a dangerous precedent for future impeachments. The first interested party asserts that adherence to constitutional and statutory provisions is paramount in such weighty matters that directly affect the sovereign right of Kenyans to elect and be served by a governor of their choice. The second interested party, FIDA Kenya, highlights that the petitioner's fundamental constitutional rights were violated throughout the impeachment process, and this was part of a larger challenge faced by women in political leadership positions. The second interested party echoed the averments by the petitioner in her supporting affidavit that she was subjected to gender discrimination contrary to Article 27 of the Constitution, and the petitioner's right to equal treatment and equal protection of the law were manifestly violated by the Senate in its proceedings. Article 50 of the Constitution guarantees every person the right to a fair hearing, yet the petitioner was denied this right when she was not allowed to present closing arguments before the Senate. This deprivation goes against established legal practices and fairness standards, and this was submitted by the second interested parties. On the key constitutional requirements for impeachment, which is public participation, the second interested party notes that the process did not meet the constitutional standards required under the law. The second interested party also raises serious concerns about gender discrimination in the impeachment process. The petitioner, being a female governor in a society which both the petitioner and the second interested party stated has strong patriarchal structures, has been subjected to relentless political persecution. They observed that the impeachment marks the fifth attempt to remove the petitioner from office, suggesting a pattern of targeted victimization rather than a genuine accountability process. FIDA Kenya argues that women in leadership positions, particularly in highly patriarchal societies like Meru, face undue scrutiny and hostility. The petitioner's case is reminiscent of historical gender-based political exclusion, where women are not given opportunities to lead. The impeachment proceedings in the Senate, to their mind, were conducted in a manner that reinforces societal biases against female leadership, discouraging other women from pursuing political careers. The second interested party also highlights that the petitioner has been subjected to multiple impeachment attempts based on the same set of allegations. The second interested party in particular proposes several legal remedies, including the nullification of the impeachment, an order reinstating the petitioner, and an injunction preventing further impeachment attempts on the same grounds. They also recommend legal reforms to protect governors from politically motivated impeachments. The Senate's role in impeachment should also be clearly defined, and adherence to due process enshrined. They urge this court to be alive to the reality behind the impeachment of the petitioner in the Senate and establish through this judgment a precedent that strengthens constitutional safeguards against abuse